welcome to this course about intellectual property. This course will be presented by my colleague Fabienne Perron and myself. We both work at the Knowledge Transfer Office of the University of Liège, called the Interface. And the Interface is a department of the university responsible for the transfer of knowledge from the university and the university hospital to the society. More specifically, Fabienne and I work as intellectual property managers. We care for the protection of results from the researchers. And hence today we will explain how to manage intellectual property as a researcher. The course will be divided into 6 points. The first point will be the different IP rights. Then we will speak about the patent and the patent procedure. We will then speak about patentability, how to do a prior art search, what is the protection conferred by a patent, and we will finish by speaking about how intellectual property is present during the research. IP is intellectual property. You should know that there is no clear definition of what is intellectual property, even at the International Office of Intellectual Property. There is no definition that is given about intellectual property, but what it says is that intellectual property relates to creations of the mind. All creations of the mind. It is something that comes up automatically as soon as you have a creation. What we mean by creations of the mind can be inventions, can be literary and artistic works, can be symbols, names, or images used in commerce. What comes up from these creations is the IP rights. And that is what is really important, is that IP rights allow creators or owners of patent, trademarks, copyrighted work to benefit from their own work or investment in a creation. So IP rights are there to give a kind of reward to creators. And these rights are outlined in the Universal Declaration of Human Rights. So as a further introduction, I would like you to think about which IP rights can be found in a smartphone. So here you can see the answers to this exercise. The name of the IP right is here, the patent. The patent can protect the different pieces of hardware, can protect method with a technical effect, such as a method to treat the data. Another example typical from a smartphone is the way you switch from one page to another page. This can be patented. Then we have a second IP right, we have the trademark. The trademark will protect the name, for example, Apple as the name of the company. It can also protect the name of a specific product, like the iPhone. Trademark can also protect a specific tune and the logo. Then we have the design. The design is really about the look, the overall shape of the phone, the position of the button, the shape and the position of the screen. So now all the smartphones tend to look at the same design, but previously, I don't know if some of you have known the Nokia the Nokia 3310, for example, had a very specific shape, and the arrangement of the button was a specific design, and we could tell that that was this kind of product just because of the specific design. Think also of the bottle of Coca-Cola. Even if there is no word on this bottle, just the shape of the bottle is recognized. And this is thanks to a specific design, and that allows to obtain an IP right. Then we have copyright. Of course, there is a lot of copyright in a smartphone. All the software, the content of the software is protected by copyright. The user manual, so the way it is written, and the music, all the music you have in a smartphone is protected by copyright, and also all the pictures, as you said in your answers. And then we have the secrets. The secrets will protect all the know-how. And to know that you have a secret, you have to take into account 3 words. The secret, it has to be identified. So you cannot just say everything is secret. That's not possible. You have to identify which part is kept secret and which effort you make to keep this secret. It has to be substantial. So this means it should not be evident to come up to that. And confidential, so yeah, it should not be known to the public and not easily accessible to the public. So this is the way to protect the secret. At the university, it is very difficult to have some protection on secrets because we have the tendency to publish all what we come up with, all the results of research. But sometimes we can have specific things that we want to protect with a secret. For example, if you work in the chemical field and you have a synthesis of reaction, and in this reaction you use a specific catalyst. If this catalyst is removed during the reaction, at the end of the reaction, when you obtain the product, you cannot see the catalyst anymore. This catalyst can be kept secret. And maybe if you want to publish about this reaction, you can have another catalyst that also works. Maybe the purity of the final product is not exactly the same, but you can speak about the reaction in a publication, in a scientific paper, without mentioning the catalyst, which really works very nicely. So now we will see more in detail the different IP rights. Let's start with trademarks. So trademarks will protect every sign with a graphical representation that enables to distinguish products or services from those of competitors. So what is important in this sentence is the graphical representation. So as soon as you can represent it graphically, you can obtain a trademark. For example, I mentioned the specific tune in a phone. This tune, you can put you can represent it with notes, with music notes. And so this sign as a trademark, you can have names, but you can also have logos. It is valid in a given territory. So when you ask for the protection of a trademark, you will ask for a specific territory. The duration of protection is 10 years. It is renewable anytime. So this is why this intellectual property right of trademark can be very long. It can last for any time as soon as you pay the renewal fees every 10 years. And it protects a certain type of product or service. There is no criteria of novelty, but it needs to be distinctive and available. I will continue with the registered design. So the design is to protect the external aspect of a product. The design can be in 2 or 3 dimensions. So design is the name that we use in English. For those of you who speak French, in French, sometimes we use design, but the correct word is modèle. Dessin ou modèle, we say dessin for 2 dimensions and modèle for 3 dimensions. What is protected is the line, the form, the color, the texture, the material. For the design, we have the condition of novelty and individual character. Also, it must be distinctive. You see here novelty. it is different from a trademark. For a trademark, you can register the trademark even if you already mention the name to the public. But for the design, it should be novel. So you cannot show your design and then ask for protection afterwards. You have to protect it first. If you recognize this picture, it is the device that is used at the university to collect saliva and have the detection of the COVID virus, SARS-CoV-2. So this object was protected by a design. There is also a patent on this protection, and these two IP rights can exist together. As you saw in a smartphone, there are many different IP rights. Here for this collection device, the patent will protect the technical aspect, and the design will protect the look, the shape of it. A second example, also from the university, this was several years ago, and I was not yet working here, but it is a specific object for the growing of plants, and the shape was developed in a specific way. So this was also protected by a design. We don't have many examples of design at the university because usually we are interested into the technical aspects and not really making things that look beautiful, you know. So, but sometimes it can happen that we have both, but it's not very common. The protection of a design is for a duration of 5 years, also on a given territory, and it is renewable up to 4 times. Copyright. Copyright is probably something that you know more easily. What is very different compared to the previous right that we saw is that copyright exists automatically. So you, as soon as you create something, you can have a copyright. The conditions to have this copyright is originality and the form. But originality is really the main point here. When you write your thesis, the purpose of a thesis is to come up with something new, something original. So you will not copy something that is already exists. So you will have a copyright protection on your thesis. But this copyright starts at the date of creation, so it is important to be able to prove the date of the creation and also to prove the paternity that it comes from you. So we will see what tools we can use to prove this date of creation. One example of tool is the e-depot. The e-depot is a way to prove the date of an invention. It does not give an IP right, and it does not prevent someone else to patent the same invention. So what it does is that you send the description of something new that you have, and it is kept secret, but it is registered with the date and with the name of the owner of what you sent. It is useful before you discuss with a company about a potential collaboration, because when you start discussing with some people outside the university, during the discussion, many ideas come up, and it happens quite often that we don't know really, or we have some conflict between different partners because we don't know who gave which idea. And in that case, everyone says, yes, I participated, so I have the idea. But it's a problem when 10 people want to have the idea, and in fact, was one person who had the idea before. So it's the e-depot is some way to attest that you have the idea. It is complementary to a confidentiality agreement. We will see further in the course about confidentiality agreements. This agreement will be binding to the partner, not to tell the ideas, but to prove what was the idea. You need an e-depot. And an e-depot, it does not cost much. And here at my department, we take care of filing this e-depot. EDDN certificate is a similar tool that is specific for software. So, you know, with software, you can have different versioning, and the source code of the software, you can also make a file with that, and this certificate will indicate the right holder and the specific conditions of exploitation of the software. So another tool that is very important for you to use is the laboratory notebook. And normally you will receive, as a participant to this course, we will send a laboratory notebook to your address of your lab to promote the use of this tool. It is very important because it enables to define the know-how you have. Every time you make an experiment, you describe in your laboratory notebook what is the purpose of the experiment and which results you obtain. It ensures the traceability of experiments. It is very important when you have to write your thesis and at the end of your thesis collect all the experiments you had, or when you write a scientific paper. So that's already a good argument to use it, but it's also an argument to attest your rights as an inventor and to prove in case of litigation. Yes, and also about being an inventor. Being an inventor is also a big story, and we often have cases at the university where it is difficult to find who is really an inventor. Usually the way we work with, it's the head of the lab who decides who is an inventor on an invention. But if you, as a researcher, you are not mentioned by the head of your lab, and you think that you really participated in an invention, you can come up to us with your laboratory notebook, showing the dates of the experiments and also showing the hypothesis you made. So when you write your laboratory notebook, it's not only just writing the experiment, but also all the hypotheses, because that's really where the invention comes from. When you make hypothesis and you say, okay, it did not work, but next time I will try to put double as much quantity, for example, and then you obtain a surprising result. So that's also something that I want to share with you in this course, is that you have also rights if you think you are an inventor, and my colleague Fabienne and I, we are used to discuss this kind of thing. So this slide is the overview of the different IP rights as we saw them. So just remember that some rights exist automatically, like the copyright. For the others, you need to register. We will see more in detail the patents in the next part of the course. For the patents, you also need to apply for it. We will see that more in detail. And for the trade secret, well, you need to make reasonable efforts to keep it secret. So let's now see about the patent. The patent is an exclusive right granted for an invention. What is an invention? An invention is a product or process that provides a new way of doing something or that offers a new technical solution to a problem. So this is the way an invention is defined by the European Patent Office. So here this example is about a European patent that was filed at the University of Liège. And you always start from a problem and you see a technical solution. In a patent, you have different drawings. You can see here it is the drawings about the shoe that was used by Michael Jackson in his video, and it is an anti-gravity, a shoe that gives the illusion of anti-gravity. So I come back to the slide. Something I want you to remember for this course is that the patent is an exchange between the society and the inventor. For the society, the inventor has to reveal the invention. He has to explain how he does it. So that's also a way to enhance innovation, because you have, through this obligation of revealing the invention, you have more ideas that are available for the public. And for you as a researcher, when you want to have new ideas for your research, you can search into the patent database, and you will see that it is an important source of knowledge. And the inventor, in return, gets exclusivity for his invention. Also, because of this system, some companies will try to go around, but then also come up with new ideas. So that's a little bit of a summary of the drawbacks and the advantages of patenting. Something that was not said is the recognition also. To have a patent is also a way to have a recognition. It can be an inspiration through the fact that it is published in the patent databases. Drawbacks are costly procedure, long procedure, the fact that you need to reveal your invention. Sometimes you do not want to say exactly how you do it. And also, if it's a way, the patent, if you see someone copying the patent, well, you need to prove that he's counterfeiting the patent. That's something also that we will see in the next part, when we see about which protection is conferred to a patent, that we will come back to that. Okay, so that was it for the introduction about the different IP rights. I have now a few slides about the patent procedure. I will not be too much detailed, because the patent procedure is something that is can be very complicated and depends country by country. There are different strategies that we can use in a patent procedure. I just want you to have some principles in mind. So you said it is a long procedure or complicated. To obtain a patent, there must be an application, and you need to file at a patent office. When you file, you can file anything. You can file just yes, if you have the money to pay for the taxes, for the fees of a patent, you can just file anything, and it will be published after 18 months. That's something that is really annoying for some researchers. They come to us because they found in the patent database something, and they say, it's impossible to have a patent on that because it's not new. Okay, but what you find in the patent databases are not necessarily accepted patents. Because patents will be accepted only after an examination procedure, and the examination occurs country by country. So coming back to in the right order, first you file a patent application, and then you receive a search report with an opinion on patentability. With this opinion, you can already have an idea, will my invention be patentable? Then you have the examination, and then in many cases, it will never be a patent. Never be a patent because the office will not accept it, and it will never be granted. Also, sometimes you don't want to pay for the tax, so you file the patent application, but you just let it go, and you stop paying for the taxes, and then it never becomes a patent. In that case, it is available for anyone to use it. To see if a patent is still valid, there is a register where we can go and check. So if you have a question about that during your research, you find something and you want to know if it is still valid or not, you can contact us for that. Another principle is the priority right. When you first file a patent application, you receive a 12-month period, so 1 year, to file the same invention in other countries. This is because the patent right exists from a long time ago in the 15th century, where people had to go by horse and traveling from one country to another country and deposit the invention at each office. So now, of course, it goes much faster because we just file online. But this 12-month period is important because during this period, we can add additional examples to the invention. It's especially useful in the university when the research is going on and there are new examples that we want to add. So this is what we call the priority year. So another principle is the publication. I already mentioned it. When you first file an application, after 18 months, you have the publication of the patent application. You have a free access with EspaceNet. And yes, I can already answer to the question that was raised in the chat. EspaceNet is a freely accessible database. You will see further after the break how we can access it. So you have access to the patent application after 18 months. Before this period of 18 months, usually you don't see if there is a patent or not. It is still secret during 18 months. And there is a register. So when you go to EspaceNet, then if you go to register, the EP register, you can see if it is valid, still valid or not. So you can go it by yourself. But it depends from country by country. And so it's quite easy to find information at some points of the procedure, but not always. It's not always easy. Remember that what you see in the patent databases are not necessarily accepted patents. I insist on that because it's very often that we have researchers coming to us thinking that it is accepted, and they are upset. they are quite upset when they see this cannot be accepted. Okay, but it's not accepted. It's not like when you publish a scientific paper and when you have a reviewer before it is published. And then you have the grant. The grant occurs on average after 4 to 5 years. So yes, it's a long procedure. It tends to be shorter. It depends country by country. Sometimes it's 2 years, but it's not a fixed duration. When it is granted, you have a new publication and you have a letter B. That's how to recognize if a patent is granted or not. You have on a patent, you have the number of the patent. I can show the one here. This is a European patent specification. You see here specification, it's not application. This is the logo of the European Patent Office. You have EP, these 2 letters are to show that it's European. and the number, and then here you have a letter B. It is granted. When it is not granted, you have a letter A. So you have several publications. First, the publication of the application, and then the publication of the grant. And you will have the US grant if the patent is granted in the US. You have in Japanese, China, and so on. Patent or publication, which to choose? Well, here this line is to show you what are the possibilities. You have here the priority filing, and before that you have the invention disclosure. Invention disclosure is something internally. It's really the starting point of any patent procedure at the university. Then you have the priority filing. You have this 12 months period wherein you can possibly fulfill the application. Then you can have a second filing, and after 18 months, publication. During this period, it is not yet known, so you have a possibility to withdraw the application. Sometimes it can happen. It's really a case-by-case decision. So the thing is that before the first filing, you cannot publish, otherwise you are not novel anymore. We will see that again with the criteria for patentability. After the publication of the application, there is no problem. After 18 months, you can also publish a scientific paper. In between, you can do it, but with risk. So what we do, we always ask inventors with whom we are working and we evaluate together the risk. In some cases, it is okay to file a scientific paper just the day after filing the patent. In some cases, it is better to wait. And yeah, this is really something to discuss. So that was to remember. Yeah. Here it's the red light is to publish a paper and then trying to patent it after. It will be very difficult. The green light is to wait before the publication of the patent application, and in between, it is possible with risk. Let's continue with some words about patentability. What is patentable? Here we will talk about what is patentable according to the European Patent Office, the European Patent Convention, because as you have already get a sense of it, it's a right that is country by country, and there might be some differences. Although the main criteria are common all over the world, it's not very different if you go to the US. There might be some differences, but just remember that here we focus on at the European level. So to be patentable, we need to have an invention, and an invention we saw that it should be something technical. Also, it has to be of industrial application. Industrial application means that it can be made in any kind of industry, including agriculture. So that's the word that we can find in the European Patent Convention. This criteria is not difficult to meet. We often have an industrial application. Second criteria is the novelty. Novelty means that it should not be a part of the state of the art. And what is the state of the art? The state of the art, also called prior art, is everything made available to the public by written means or by oral means before the date of filing. State of the art is something very, very broad. No matter the country, no matter of the date, it can be a document that is from 1900. It is state of the art. It can be something that is published in a little country in Africa. It is state of the art. No matter the language, something that is said in a conference orally, if it is a public conference, it is state of the art. So pay attention. If you want to file a patent, any scientific paper you have published before is state of the art. Any poster, any abstract, web page, or even if it is put on the market, it is considered prior art. The main problem we have here at the university is about abstract, because you see that there is a conference in 6 months in Hawaii, and you think, okay, sorry, that was the time where we could still travel, but it will come back. You think, I want to go to this conference, and the deadline to file an abstract is tomorrow. So because I want to present something at the conference, I want to send an abstract, and I need to write very fast something to submit the abstract for tomorrow. And if in this abstract you tell the main features of your invention, it will not be new anymore, because this abstract will be available on the web page of the conference, will be published in the proceedings, and so that's something that can be problematic. So if you need to write an abstract, and we know that it's something that is important for researcher, think about not revealing the main features of your invention. I have a very simple example. Imagine you make an apple cake, and you have the recipe of your apple cake. Don't tell the recipe and all the ingredients of your apple cake, but you can tell how delicious the apple cake is. So you can tell the properties or that you have, but you don't tell the recipe of how you obtain that. That's, in short, what we can recommend to do to have key possibility to patent the invention. And the third criteria is the inventive step. Inventive step means that it should not be obvious for a person skilled in the art. And the person skilled in the art, how is it defined? It is someone that knows everything he should know in the field, but he has zero imagination. So he has read the literature in the field, but he is not able to combine different documents together if he has no incentive to do so. So you see that this criteria is already something more difficult than novelty. And we will do an exercise so that you can understand how this inventive step is evaluated. It is really the obvious or not obvious to come up to the invention. There are some exceptions to patentability. Here I will talk about the main exceptions. We will not go into the different details because I can give a course only on that. But remember that what is not patentable according to the European Patent Convention is first inventions that are contrary to the ordre public or the morality. This is an example is the anti-personnel mines. If there is too much damage possible with a weapon, so then you have no benefit, then it is not patentable. But if some way you can explain that it is for defense, then it is patentable, but then we will evaluate how damageable it will be for the society. That's the ordre public. And morality, it is more like about human embryos, for example. You cannot patent human embryos. Second point is plant or animal varieties. If it is obtained by essentially biological process, it is the breeding of plants or the breeding of animals that is not patentable. But if you use biotechnology to obtain genetically modified animals or genetically modified plants, then it will be patentable in some way. So here it's really about the varieties, because that's something that occurs, that may occur in nature, and we cannot patent the nature. That's really the idea that you have to keep. If it is existing in nature, it's not an invention, it's not technical. And then the third big category is the method of treatment of the human or the animal body by surgery or by therapy, and also diagnostic methods practiced on the human or the animal body. So that is excluded because we don't want to prevent doctors from the medical acts of what they do on the human or the animal body. So really the method of treatment is not patentable in Europe. In the US it can be, but we can protect the instrument, the surgical instrument. We can have a protection on the instrument, but not on the use of the instrument. So yeah, that's really a method for treatments.
So prior art search means searching into the state of the art to determine if the invention is really new. For you remember, novelty is one of the criteria of patentability. In this module, I will explain to you why it is relevant to determine this criteria and how it is possible to achieve it. So, it is important to search for prior art to make sure that the invention doesn't exist already somewhere in the world, or doesn't simply reinvent the wheel. So let's begin with this exercise or this example to understand this notion of prior art. First page, on the left side of this slide, you see the first page of a patent application. And this patent application proposes to solve the problem of excessive wear of aircraft wheels when they touch the ground. It was a problem. It could be a problem of explosion of the wheels due to excessive acceleration. So that's the problem. And the proposed solution is resumed in the abstract, which is difficult to read, but you have the figures to understand the invention that was proposed. So the proposed solution is resumed as it consists on small fins on the side of the aircraft wheels so that they rotate during landing, and this without an electric motor. And this solution allows to avoid explosion. So this patent application was filed in Great Britain. You see the double code of GB for country code for Great Britain. And this patent application was filed in the Great Britain office, and the examiner, when you receive this patent application, he began to search, to evaluate the criteria of patentability. Then he has done a prior art search to evaluate if this patent application was new. And then he found a US patent that you can see. You see the first page on the right side of this slide, and it is a US patent that was granted. You see the double code of the country code of this patent. So, and this patent was filed in 1929. And in this patent, this patent claimed wheels of an aircraft with pockets allowing to the wheels to rotate. So the same solution, but not the same, but in the same way. The solution was in the same way, and this old patent was considered by the examiner as a precedent of this patent application that was filed in Great Britain. So in language of patents, we name it was a disclosure of the invention. And therefore, it was considered as an obstacle to obtain the patentability of this Great Britain patent application that was filed in Great Britain. And so the examiner didn't consider the patent application as new. So this slide illustrates the state of the art. Prior art or state of the art, it is the same. So the state of the art is composed of published information. On the right side, on the left side, sorry, you see the blue circle representing published elsewhere and scientific or general information. And on the right side, on the right circle, this circle represents published information, information that was published in patents. And we consider that in general, it is there is about 80% of the technical information that is detectable only in patent documents, and nowhere else will it be so detailed. So my first advice to you is please search, read, and use information identified in patent documents for your R&D project. You will be surprised how it will be a complement of scientific literature. So that's all to understand that's all of my presentation to understand why it is important to search this information and to know it. And now we will go to the next slide. To understand how it is possible. How it is possible to search for patent and how to conduct a search in a patent database. So let's use ESPASnet, which is the worldwide patent database provided by the European Patent Office. This database is free of charge and very user-friendly. Please, you have firstly the smart search, which is usable if you receive, for example, a reference number of a patent, or if you want to search the patent filed by an inventor or by a company, then use this smart search. Only one word or one name, or perhaps a simple combination of keywords. Then you can begin by using this smart search. And then after that, when you receive the search, the results, then use the advanced search. Then you will have the opportunity to combine the different identifier fields. For example, you can combine keywords or a combination of keywords with, for example, a date, a publication date, or perhaps with the name of an inventor or with the name of a company. Then you will refine your search. So, how many patent applications were filed by the University de Liège, Université de Liège in 2020? So that's, I think, I have a PowerPoint explaining the correction of this exercise. So do not search, in resume, do not search for trademark. Look for the name of the molecule, of the chemical molecule through search engine. So aspirin is acetyl salicylic acid. Type acetyl salicylic acid in the smart search or advanced search. And then refine the results by the priority date. And as you have seen, it is possible to sort by priority date. And the good result was process for producing acetyl salicylic from Leonard Lederer. So now let's begin with the module focus on the protection conferred by a patent. Alors, which protection does a patent confer? A patent is a right to prohibit in protected territory, also in countries where the patent is still valid, for a limited period. In general, the period is of 20 years. There are some exceptions in the domain of phytopharmaceutical or pharmaceutical products. Then there is the opportunity to get a prolongement of the duration of maximum 5 years. But in general, a patent, the duration of a patent is of 20 years maximum. So an invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. Let's do an exercise. If you have a patent, do you necessarily have the right to use your invention? I will perhaps repeat the previous slide. So the protection conferred by patents is a right to prohibit. So the invention cannot be commercially made, used, distributed, or sold without the patent owner's consent. And the owner has the right to prohibit the use of its own invention. But for its own authorization to use this invention, it is not the same. So the patent is a right to prohibit, others to use. So, sorry. So the patent is a right to prohibit others to use without the consent of the owner of the patent. It doesn't give any right to the owner to use its own protected technology. To do this, the owner has to request for license to use the technology, to request for a marketing authorization. But if this technology is already protected, or part of this technology is protected, or perhaps if he need some another technology to use its own technology in good condition, then he won't have the right to use its own technology. So please keep in mind that a patent is a right to prohibit the others to use the technology without the consent of the owner. Is it right for you? So let's do this exercise to illustrate the patent, the right conferred by a patent. So we have a blue circle representing virtually the scope of the patent patent A that protects a bicycle, which is defined in the patent as a vehicle comprising 2 wheels, a handlebar, a seat, and pedals. And then we have a patent B that protects a bicycle with additional element, which is brake. And this additional element is considered as a very relevant element and inventive element. So this patent B is included in the big circle in the scope of the patent A, but with a specific element. If patent A is still in force and valid in the country of interest, then the owner of patent B needs the authorization of patent A owner. Also, patent B, the owner of patent B has right to prohibit the others to use his technology, also a bicycle, to produce or to sell a bicycle with brakes, and if he doesn't give the consent, then third party cannot use this technology. I hope it's right for you. Alors, so I repeat that a patent is a right to prohibit the other to use without the consent of the owner. So what is infringement or counterpart? As a general principle, any person not having the patent proprietary or patent owner consents is prohibited from certain acts, and breach of those prohibition will constitute patent infringement. So making use of a patented product or process without the consent of the patent owner is act of infringement. So I repeat, the act of use is producing, offering for sale, putting on the market, importing, or stocking the product. Infringement is determined by national courts. It could be different because the national laws are different, considered the infringement. It could be different from country to country. And what constitutes infringement in one country may differ from other countries. So the patent owners can claim damages or other financial remedies from alleged infringers. So that's the infringement. How is infringement determined? The extent of protection is determined by the claims of the patent. Remember, the claims of the patent are the core of the patent. Claims define the scope and the features of the invention. Infringement occurs when the infringing product possesses all the features of the claimed invention. So to determine the infringement, it's important to analyze the claims. So what the owner claims as its own invention. And all the steps of the claims are analyzed. And if third party uses all these steps, then it will be considered as counterfeiting or infringement. Let's do an exercise to illustrate it. We have on the example shown here is about two companies that are commercially active in the market of scissors. So Paperfix that you see on the left side of this slide is a company that produces scissors with eye-rings covered by plastic. Paperfix produces these scissors with eye-rings in Italy, and Paperfix sells these scissors in UK. And in the other side, so in the right side, we have the company Henricut that has a UK patent. So in UK, Henricut has a granted patent, and this patent claims cutting means with two eye rings. Alors, what's your meaning? What's your opinion? Is Paperfix infringing Henricut's patent? Let's do the resolution of this exercise. How is infringement determined? Alors, are Paperfix infringing Henricut's patent? Alors, so first we have the scope of the Henricut's patent related to cutting means with two eye rings. That's the scope of the patent from Henricut. And in this scope, we have the patent we have the production from Paperfix related to scissors with plastic eye rings. Paperfix produces these key sources in Italy and sell them in UK. So the first point to be analyzed is, generally speaking, production and sales are acts of infringement. So in UK, the patent related to cutting means with 2 eye rings is protected. So Paperfix, when Paperfix sells ski source in UK, then it is considered as infringement because the ski sources are within the extent of protection. But in Italy, if Paperfix is producing the ski source in Italy, also outside of UK, then Paperfix or any others that produce the ski source outside the UK are not considered as infringer, because the technology of haircuts is only protected in UK. Alors, there is another question. So, is it clear for this point? I don't think so. Julie, don't think so. So, the first step to evaluate the infringement was, firstly, are those acts considered as acts of infringement? Yes. Sale or production are considered as acts of infringement. Second point, in which country? In which territory? So if these acts of infringement are done in a country where the technology is protected, then it could be considered as infringement. If the act of infringement are done in country where the technology is not protected, then it is not infringement or counterfeiting. Alors, there is this last questions. What about the garden shears imported into the UK by another company, for example, from the name Shearman? So it is a ski saw means, but is this cutting means with 2 eye rings? Okay, Julie, I understand. So now we are speaking about the question of the garden shears imported into UK by Shearman. Is it considered as infringement or not if we base or analyze on the haircuts patent? Alors, Anthony, it's not infringement because there are no eye rings. Is it clear? And I agree with your answer. So is it clear for everybody? Yes. For Karine, for Anthony. So no, the shears do not have eye rings, so they are outside the extent of protection. So that's all for this module. And now I will let Elodie for the last module.
Thank you, Fabienne. So here I'm back again for this last part, IP and research. So the thing is to see with you, when should you think IP in the different steps of your research? And it's also a way to integrate all the notions that we have seen today, and to link it with your research. So the first point is, when you prepare a new research project, it is important to know if your research is free of rights, so that you do not reinvent the wheel. Also, what we have not yet seen is that you can it can help you to define an exploitation scheme of results. By exploitation scheme, we want to say who will be interested in the results of the research. So which companies are active in the field. You can also use the patent databases to find companies active in the field. And also, when you do such an exploitation scheme, or when you have already industry partners in your research project, which will be the rights that will be needed by each industrial partner in the project. That's also part of the exploitation scheme, to see who will need which IP rights. Then, if you are in a project with different partners, you need to establish a consortium agreement, which we also called a joint research agreement. In this agreement, there are several points wherein intellectual property has importance. It states to whom goes the property of the results. Does the university has the property, or is it the industrial partner who has the property of the results? This will be written in the agreement. At which moment do we have exploitation of IP rights, under which conditions? This can also be defined in the agreement. And another point is the confidentiality. It has to be stated in the agreement what is considered as confidential. Is it all the results? Sometimes we put a sentence to say that is confidential only when there is a mention of confidential, a mention in an exchange of emails, for example. If you need to specify that it is confidential, so that it falls down under this category of protection. So that's really to raise your attention to that, so that if such an issue comes up during your research, you know that there are some agreements to consider to find the answers. Next step is you obtained the results and you want to protect those results. So which IP right will you use to protect the results? Is it the intention of the team to file a trademark? Is it the intention to keep it secret or to patent it? If we decide to patent, when will be the best time to file a patent application? That's really important, because if we file too late, you may already have published or a scientific paper, or you may have presented it at a conference, so it will be too late. But if you file too early, then you will have important costs occurring in the patent procedure, and it will be difficult to find a company wishing to take a license agreement on this patent if the results are too early. I did not yet speak about the costs of patent application. So the beginning, when at filing, you have to consider that it is about 10,000 euro to file. That's really an order of magnitude, 10,000 euro. And then if we want to have more countries, then at the end of the priority year, we can file other applications. And then it's again another 10,000 euro if we choose the international route, which I did not detail here today. And then if you have translations, if you want to translate the application in Chinese, in Japanese, that's also another couple of euros to add. And then you have the maintenance fee. That's every year maintenance fee, and it goes exponentially. In the beginning, you will start with 1,000 euro renewal fees, but at the end of the patent, if you have many countries, it can become very high, and it can go to 100,000 euros. But here at the university, what we do is that we take the cost in the first year, and then we try to find a company interested in this application, and then the company takes over the cost for the next years. So that's why the timing is also important. And the most difficult is probably in the biotech field, because it takes some time to do in vitro studies and then in vivo studies. So that's a more kind of issue. Also an issue during the protection of results is to find who is an inventor. And this is why it's the picture of the laboratory handbook is there again to insist on that. submit an invention disclosure. So that's a necessary step for us to take the file and analyze it with you. We will analyze with the researcher the prior art to see if the invention is patentable. And we will also do a market search to see if there is some interest in the market for the invention. Is there a potential to find companies interested? Or we evaluate if there is a potential to create a new company. With all this analysis, we can define a strategy for protection. And then the next step will be the license agreement. A license agreement is an agreement during which you allow someone else to exploit the invention in exchange of a return. Exchange of a return, the return, it can be a return in money, but it can also take other forms of return. It can also be that new collaborations with the company. It's not always focused on getting the biggest money out of it. It's really a case-by-case analysis, and especially when an invention is exploited through a new company, we will not ask the new company to pay directly the costs in the first years. We will delay the cost with the company, evaluating when the company makes benefit from the invention. This is why one way to have a commercial return is through royalties. Royalties is a percentage of revenue based on the sales of the product or the service. So you have the sale numbers, and from this sale number, a percentage comes back to the university. So GESVAL is a company owned by the university, and that cares for the management of the IP rights. So, but in fact, GESVAL is fully owned by the university. So just remember that it's the university and my department, so Interface, which analyze that, and we have some colleagues that are specialized in this kind of selling the patent. And the inventors are involved. The biggest successful stories that we have, it's always when the inventor himself or herself went and defended the invention to companies or to yes, others, because it's always the inventor who speaks the best about his invention. It's like a baby, of course. So we are there to help and analyze and find. Of course, it's our job also to find the licensee. So the ones that agree a license will be called the licensee, but it's together with the inventors. Also, in the patent procedure, it's very important to have the involvement of the researchers, because we have to defend the patent. When we receive an opinion of a patent office about the patentability, sometimes the examiner is not convinced by the patentability, but we can argue and explain why we think that it is novel and why we think that it is inventive. And the inventors are needed to help find the right arguments together with us, because we have the ability to know how patents are written and how the procedure goes. So it's really a collaboration. So here the last slide is about who gets the income, and I had the opportunity to already talk about it when there was a question in the chat about to whom goes the results. So as a reminder, the university is the owner of the results generated within it. This is specified in the IP regulations of the university. And in the IP regulations, this rule of 3/3 is explained: 1/3 for the university, 1/3 for the research unit. There may be more than one research unit, so it is divided among the different research units, and 1/3 divided among the inventors. Also, as a reminder what not to do when considering filing a patent application, no publication prior to filing. I think we already insisted on that. And then also to remind you of the importance of non-disclosure agreement. We call it either confidentiality agreement or we call it non-disclosure agreement. In short, it is called the NDAs or CDAs. Yeah, NDA is more common. So that's an agreement to be bound by the confidentiality and to protect the disclosure. Another agreement that is important is the material transfer agreement, because when you receive a material from a partner, or on the contrary, when you send material to a partner, it is important to define what will be the property of this material. Usually, we need to keep the property of the material. It's not because we transfer the material that we transfer the property, but what if the partner improves the material? What will be his rights? That should be defined to avoid any issue, and that's the purpose of a material transfer agreement. So maybe you will receive such material transfer agreements to sign from a partner. You should always review this agreement and let it review by a legal advisor before you sign such agreements. The same for the non-disclosure agreement. You may receive some agreements from a partner. It is better to let them review, and it is also better to take our models. We have models of such agreements available on the website of the university, available on the website. It's the page of the legal department of the university. You can download these agreements and you can send them to the partners. So that's really important to use this when you collaborate outside the university. Here the link, myresearch.uliège.be is now the place where all the information is gathered. All what we said today about intellectual property and more information also around what we do to help you with all these issues. It is still under construction, and some pages still need to be translated in English, but at least in French, now that it's a very useful source of information.